Well, once again, I don't know how many of you remember that television show. I might be dating myself, but that was Dragnet, an old show, one of my favorite shows. The name of this seminar is To Relate or Not to Relate. That is the question. Or otherwise, I say, just the facts, ma'am, just the facts, just like Sergeant Joe Friday. This involves common misunderstandings regarding notice of related cases. I know it's not the sexiest subject, but believe it or not, it's an important subject, especially if you are a civil litigator. I'm Judge Hammock. I wear a robe in Department 49, Stanley Mosk Courthouse. Okay, and this entire webinar or MCLE class is based upon an article that I've written. It came out this summer in the Advocate magazine, the June 22nd, 2022 edition. Everything you needed to know about related cases is contained in that article. You could certainly Google it, or you could actually call my court clerk. We'd be glad to send you a copy of it if you want. Okay, what is a notice of related case, which I'll say NRRC for further reference. Believe it or not, this is a mandatory document which must be filed whenever there's a reasonable possibility that there is another potential related case. Here's the key, and this is one of the first mistakes that people make. Of course, it could be a currently active or pending case. That's easy, that's a no-brainer. Believe it or not, though, the notice of related case might be a case that was dismissed 20 years ago, or it's no longer active or pending. That's the first fundamental mistake that everyone makes in my courtroom. Even the judges make it, because you instinctively think, I only need to file a notice of related case if there's some other pending case out there. In other words, so that judge that's handling that case can handle the newly filed case. That's wrong. Any possible case, even if it was dismissed or went to trial, was no longer pending or active, you still must file a notice of related case. So why is that? Because a lot of times, maybe it was discussed, it was dismissed a few years ago, but maybe the same judge is still there. And that judge might have familiarity with some of the facts or some of the issues. Or maybe, we get research attorneys and they're assigned to courtrooms sometimes. Maybe the research attorney will know something about the case. It really is trying to, even though the judge is no longer pending, it's a different judge in the closed case. Maybe the new judge feels that it's a good idea to relate the cases for whatever reason. So always keep that in mind. It's not necessarily limited to currently active or pending cases. It could be no longer active or pending. You still must file the notice of related case. Filing a notice of related case allows the trial court to promote efficiency, to avoid duplicative effort, to combat judge shopping. That's important. And to minimize the prospect of conflicting results. Now think about that for a second. Let's just say you file a case, and maybe the judge does not turn out to be the judge that you actually won on the case, but it's too late for you to file a 170.6. Oh, I tell you what I'll do. I'll just dismiss the case without prejudice, refile it, and then I have a 1 out of 42 chance of getting a different judge. So I've now be able to, even though I no longer have a 170.6, I just devised a way to get rid of this judge who I think is not really the judge I would like to have in my case. And so this prevents that, because once you file the new case, you must file a notice of related case. And believe it or not, it goes back to the old judge. And that judge can determine whether or not they're going to relate the case. And they should. And then you have to say to yourself, okay, what if I do that? What if I go ahead and I dismiss the case, I refile it, I file the notice of related case, it gets sent back to the original judge, that judge says, I'm going to relate the case, and then I file a new 170.6 on that judge. because as we'll discuss later, you can file 170.6s in new cases. But this, if you look at 170.6, which we're not going to really talk about a lot, this is the new case is really a continuation of the old case. And under the continuation doctrine, you don't have a paper. You can't disqualify that judge. Now, don't forget, you can always disqualify for cause, 170.1. Good luck on that, okay? But you can, right? But you don't have the discretionary 170.6 challenge. And that's one of the main goals. As you say, the goals are efficiency. We want one judge to hear similar types of cases that are related. We also would prevent this judge shopping, form shopping. And we want to minimize the prospect of conflicting results. What if we had two related cases and they should have been related and we get two different judges and they make opposite decisions on the same issue? We want to try to avoid that, okay? So always keep that in mind. The reasons why you're required to file a notice of related case. Okay, so let's talk about the definition of a related case. These are all straight from the California Rules of Court, all right? A pending civil case is related to another pending civil case. This is the key. Or to a civil case that was dismissed with or without prejudice. Or to a civil case that was disposed of by judgment. That's what the rule says. So I always kind of smile when I confront counsel at the CMC. There was this related case. Why didn't you file a notice of related case? Well, judge, that case has been dismissed. All you have to do is read the rule. It clearly says in there, it doesn't matter whether it's been dismissed, all right, with or without prejudice, or it actually went to a judgment. It doesn't matter. You're still required. It says shall. Okay, you have to file it. Now, here are the possibilities of related cases. Involves the same parties and are based on the same or similar claim. That should be a no-brainer. That's clear. Arise from the same or substantially identical transactions, incidents, or events requiring the determination of the same or substantially identical questions of fact or law. I had a case today on my calendar. It was 5 separately filed wage and hour claims, 5 different employees against the same employer with different lawyers. I still related the cases, even though they might never be consolidated. I'm certainly going to relate them so because I can coordinate them potentially for discovery. I can do a lot of things that are more efficient and not have a lot of overlap. So that gives you one example. That I think at one time I think I had a case that had 9 related cases, but 5's a lot. Typically 1 or 2 is what you normally have. So it doesn't have to, okay, again, involves claims against Title II possession of or damage to the same property, a quiet title action. Then somebody else has an unlawful detainer, and then somebody else has something else. Those should be all related because even though there might be separate lawsuits and they don't ever get consolidated, they won't get consolidated, they should at least be related because they involve the same subject property, okay? So now we know the right hand will always know what the left hand is doing. And then here's a catch-all. This is the interesting one. Are likely for other reasons to require substantial duplication of judicial resources. This is kind of the catch-all. There's just some reason why we should have one judge hear these cases, okay? Now, don't get me wrong. Song Beverly cases, we get a lot of Song Beverly cases here, okay? I think about 10 to 15% of an average IC docket is Song Beverly. We don't designate one judge to hear all the Song Beverly. We're all going to hear the different Song Beverly cases. So just because one law firm has 150 cases against General Motors, don't file a notice of related case in that, okay? The different judges will hear that because every Song Beverly case is different on the facts. So I'm not suggesting that. But again, a classic example would be like a wage and hour. You had 5 different employees. There were different employees doing different things. And there were 5 separate cases against this one employer. That seems like that's a possible related case, okay? So always remember there's a catch-all. Remember, as I always say, it's not a notice of identical cases, okay? That's what always people say to me. Oh, Judge, they're not the same case. Well, I understand that they're not the same case, okay? They don't have the same case number, okay? But again, it's not notice of identical cases. It's notice of related cases, substantially similar cases, okay? They don't have to be identical, all right? There's just got to be some reason that logically it makes sense to have one judge be assigned to hear the cases. Once again, they don't have to be coordinated in another way or consolidated. Always remember, fun fact, you can never consolidate a case until they're first related. You must first have the judge relate the case before you can consolidate it, okay? Now going on, duty to provide notice. Now, whenever a party in a civil action knows or learns that the action or proceeding is related to another action, blah, 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 the party must serve and file a notice of related case. So it's a mandatory duty, okay? Here's what the contents would say. 1, list all civil cases, that are related by court, case name, number, and filing date. Identify the case that has the earliest filing date and the court and department in which the case is pending, and describe the manner in which they are related. Now, we're going to go over a form that you could use for this. There's an optional form that you use that has all the information. And I would urge you to use the optional form, and we'll go over it in a second, but it's not a mandatory form. So if you're not going to use the court form or judicial council form, just make sure it contains all that information. And I would urge you, the earliest case is number 1. And then you do it chronologically by its filing. Now, don't be confused. I swear I've had cases in which you look at the case number and they're really close. You know, it ends in 130 and the other ends in 137. Don't just assume that the 137 was filed after 130. I'm telling you, sometimes if they're filed on the same date, they get processed by time at night. And I have had cases, it's rare, but I have had cases where they were filed on the same, someone files a notice of related case, I have to make the decision. We'll go over that in a second. And I look and I go, oh God, I'm the lowest case number. Drag, I gotta make a decision. But then I notice, hey, they're filed on the same day. So let's see who filed it first, okay? And I'll look at the time. And I have literally seen it where my case, even though I have a lower case number, was actually filed 30 minutes later. It doesn't say lowest case number. It doesn't say lowest case number. It says time of filing. It's when it was filed, the earliest filed, okay? And filing, it's probably being processed by the clerk, okay? So keep that in mind. Just because you're the lowest case number doesn't mean that it was the earliest file, but generally 99% of the time it is. Okay, so here's another mistake people make, big mistake. All right, they file a new case, right? You get this new case number, you get signed to Judge Hammock, Department 49. All right, there's a notice, there's a related case. And so what you do under my new case number, you file the notice of related case. And that's all you do. Wrong. You have to file the notice of related case under each and every case number. So you take the form, or if you don't use the form, whatever you file, and you literally file the same thing under every case number that's going to be on it. Okay, very important. All right, let's say we'll just make it easy. There's one possible notice of related case. It was earlier filed. So you just filed a new one, and you're aware of this earlier case that might be related. You file the notice of related case under both case numbers. And under the earliest case number, you list the new case. And under the new case number, you list the earliest case, because they will go to each respective judge in our queue. And so let's say something comes up to me and I'm down the pack. I'm number 2, 3, 4, or 5. I don't even think about it. I don't even, because there's no decision for me to make. Because the judge that has the earliest filed case is the one that makes the decision. All right. But how is the judge with the earliest filed case ever going to know about it unless you file a notice of related case under that judge's case number? You see my point? Very common mistake. They say, Judge, I filed it. Well, yeah, you filed it under my case number. You need to file it under the other case number, letting them know that my case might be related. Okay? So keep that in mind. Another common mistake. All right. And believe it or not, you have to serve it on all parties and all lawyers in every case that is a possible notice of related case. All right. You have to file it as soon as possible, but no later than 15 days after the facts become aware of the facts that there's a possible related case. And then you have a continuing duty to provide notice. Let's just say you file a case, you're not aware of any case, and then later on you discover, oh my God, I didn't know there's this related case. And it's months or years later. I literally, last week I had one, it was going to trial, and I realized there was a related case that was filed 3 years ago that was still pending. Believe it or not, I ordered them to file a notice of related case. All right, because that judge had a similar case, and the judge ended up taking the case. All right, even though I spent all this time and had the case for years. You always have a continuing duty to file a notice of related case. Let the judge make the decision. Maybe the judge, as we'll talk about later, will decide, well, you know, the other judge has been working on it for years. I don't really feel the need to relate the cases. And unfortunately, the way it goes, let's just say we have 2 cases that are related. And the earliest filed case decides, the judge says, you know what, I'm not going to exercise my discretion. I'm not going to relate the case. The new judge doesn't get the number 1 case. You can't have the new judge take 1. You can have 1 take 2 and 3, but you can't have 2 take 1. Okay? Keep that in mind. Now, rarely do I see responses filed. Someone files a notice of related case. Technically, the court, and I think judges make a mistake because they just rule on it right away. You're supposed to wait 5 days and see if anybody and all those lawyers and parties that got notice of it wants to object and tell me, no, I don't think you should relate them, or yes, I think you should relate them. You're allowed to file a response when you get a notice of related case from the other side, whether or not you think that judge who will make the decision should relate it or not. Okay, you have 5 days, and then you have to file it in all pending cases. Don't forget, any case that's listed as a related case, you have to serve everybody in that notice of related case. People rarely do this, but you know, maybe you don't want the cases to be related, or maybe you really do, and so you must. These are optional. You're not required to file a response. It says may. The party may serve and file a response. Ironically, I don't think. Let's say you're under a duty to file a related case because it might be related under an objective standpoint. But you don't want them related. You do not want the cases related. You still must file the notice of related case. And then you can file a brief telling the judge why you don't think the judge should relate it. Okay? And the judge will read it and consider it. So there's no, it says, because it says, ironic, it says within 5 days of service, the party may serve and file. Any party can serve and file a response. And I've actually had cases where they were taking opposite positions as to whether or not that I should relate the cases or not. Okay? And I could even have a hearing, I guess, if I wanted to. You could try to convince me one way or the other. There's no hurry. All right. Judicial actions. Now I get a notice of related case. I'm going to make the call. I'm the earliest filed case. Okay. Look at the key word. I highlighted it. May. Yours is shall. You actually have to file the notice of related case. And even though it fits every definition of a related case, And if you open up Black's Law Dictionary under related case, it'll have a picture of both cases. I still don't have to relate the cases. It's completely within my discretion. All right. So it says may order. Even though they fit all 4 definitions of related cases are there. Okay. I've literally seen judges, they tried the case. The case went to a bench trial in front of them. And then there was a malpractice case that came out of it, comes to me. I, of course, ordered them to file a notice of related case to the judge who did the underlying case where the alleged malpractice occurred. The judge denied it. I can't do anything about it. All right. That's the judge's call. It's discretionary. Okay. All right. So now sometimes you get, okay, so that's A. Look at that. The judge who has the earliest filed case must determine whether the cases are related or not. Okay. So that judge makes a call. Now, here's an interesting point. Let's just say you have 3 possible related cases, 1, 2, and 3. 1 is the earliest filed case, and that judge says, no, not going to do it. Denied. Believe it or not, you go to 2, and 2 asks 2 if they want to take 3. 2 can't take 1, but 2 can take 3. You see, 2 can take any case after 2, because it would be the earliest filed case to 3 and 4 and 5. But 2, and it works. Let's say if there's 4, you ask 1 first. 1 can't pick and choose. They got to relate. Well, I guess they could pick and choose. I don't know why not. They could think 1's related and 1's not related. 1 chooses, and if there's more than 2 left, 2 chooses, 3 down the line. It rarely happens, but technically that's probably true. Now, if sometimes it's rare, you get a mixture between unlimited and limited civil cases. Okay, it doesn't matter. Unlimited does not trump limited. Okay, look what it says. The judge who has the earliest filed unlimited case. Actually, it doesn't. I misspoke. Unlimited will trump limited. Even the limited was filed earlier, because I can always bring a limited up to unlimited. And that case will still stay within the $25,000 jurisdictional limit. But I can't bring an unlimited to limited. You see how that works? Unlimited cannot go to limited. I guess unless they want to stipulate that they can't go beyond 25,000, which would be pretty unusual. All right. Or it's not qualified under the limited statutes. Okay. So keep this in mind. Sometimes you have a limited and unlimited. The unlimited will control, even if it was filed later, where the cases listed include both unlimited and limited. The judge who has the earliest filed unlimited case determines. Okay. Little quirky. I rarely see it happen, but it happens now and then. It does happen now and then. Continue on. All right, this is where it gets really super complicated. I get cases, notice related cases, in which it's a civil case, and then they think there's a possible probate or family law case. It happens more often than you think. Believe it or not, I get will contests filed in my department, and I'm saying to myself, why do I have a will contest? Okay, isn't it what probate does? And I always make them file a notice of related case in the pending probate matter. Okay, and let the probate court decide what happens. But here's the key: it says the presiding judge or judge designated by the presiding judge. In our case, don't go to the presiding judge. You go to the supervising judge of civil. Let me repeat that. The supervising judge of civil makes the call. If it's between civil and family law, the supervising judge of civil makes the call. If it's between civil and probate, the supervising judge of civil makes the call. The supervising judge of civil makes the call. Now, he or she could confer with the supervising judge of probate or family law, but it's my understanding that you file the notice of related case in Department 1 and let them make the call. Okay? Now and then they get granted, and the cases go to wherever they should be. Okay? Continuing on. Now, this is a little interesting quirk. let's just say the judge now that makes the call says, no, I'm not relating the case. And you're not happy about that. You think the cases should be related for whatever reason. Any party, if it's related, not ordered, any party in any of the cases may file a motion to have the, I bet you very few of you have ever even known this rule. It's so obscure. All right. You could file a motion to have the cases related. And that motion is heard by the supervising judge of civil. Okay. And so but here's the key. It says not ordered. In other words, if the judge orders it related, you have no recourse. It says not ordered. Okay. Very important. And then, so if you think they should have been related and you're not happy that the judge is not taking it, then you can file a notice motion in Department 1. And believe it or not, Department 1 makes the call. Here's the motion. You can file your opposition, file whatever you want to file, and then they'll have a hearing and they'll issue a ruling. And I've seen Department 1 overrule basically the trial judge and says, no, you're taking the case. You have no choice.
Judge Hammock, we have a question on this issue.
Yes.
If we're up to it.
Please.
What happens if the first judge, the first filing judge is no longer on the bench and there was a judgment?
It would go to the courtroom. As I said to you before, it doesn't matter. It's courtrooms. It's courtrooms.
Okay.
Okay. Good question. Even though the judge, and a lot of times I have taken related cases where I never saw the case before. Okay. I took cases from, when I wasn't even here. Okay. Because sometimes it made sense for me to do it. But that's a good question.
One more question if you're up to it. Okay. So what happens if the notice of related case is related to a case in a different county?
We're going to cover that. It's coming up.
Okay, great.
Okay. In fact, all right. So let's go to that point right now. Here we go. Related cases pending in different superior courts. Hey, there's the rule. All right. Again, the judge who has the earlier case, wherever that is, whatever county that judge is, that judge makes the decision. Okay. And you can see it. He doesn't really get to poach. Here's what's going to happen. That judge is the one that kind of takes charge. And they talk to the parties on all the cases, including the judge in the other county. And they see if they can reach a consensus, to determine the feasibility and desirability of joint discovery orders. So in other words, that judge with the earliest filed case, wherever that is, can't just automatically poach it from another county. That would be insane, okay? Especially if the county's up, Del Norte, okay? Right at the Oregon border, all right? So what's gonna happen? You look at the rule, the earliest filed case may confer informally with the parties and the judge to see if they can coordinate it and not have to do a formal related case. And then here's the catch. If it is determined that related cases pending in different superior courts should be formally coordinated, all right, under these rules, then you file a petition with the Judicial Council and they take over and they figure out which of the judges is going to handle the case. All right. So in other words, this is a rare thing. The earliest judge, the earliest filed case, no matter what county, tries to do it informally and see what we can do. But if somebody insists, no, we think the cases should be related and coordinated or consolidated, and then you follow those procedures and those rules, and you basically file a petition with the Judicial Council, and then they make the determination. It's very complicated. I've only had it once or twice, and I've been in an IC court for almost 7 years. It's very rare, okay? But you believe it or not, you have to file a notice of related case and let someone else make the call. Complex cases, hey, none of this applies to complex cases. If it's deemed complex, or you file in the complex court, or I deem it complex, provisions of 1 do not apply. There's an exception if it's been designated complex, okay? Now, let's say now I make a decision. I'm going to issue an order granting or denying the notice of related case. I have to file a notice. This is me now. I have to file a notice of the order, my ruling, my minute order, and serve a copy on everybody listed on all the possible related cases, okay? Or I can direct, what's what I normally do? I direct counsel for the person that filed the notice of related case to give notice to all interested parties, okay? Whichever ruling it is. So that's important. And that's typically what I do. Now, let's just say I don't relate it, okay? The status quo remains. That case will remain assigned to the court, judge, or department, blah, 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 blah. In other words, I denied it. It's like nothing has changed. You could file your notice motion in Department 1 to get it reviewed. And I think it's a de novo review, to be honest with you. I really do, but I'm not 100% sure. All right. But if it's denied, then you comply with your duty to file the notice of related case, and everyone stays still. Okay. There's an exception. A party is not required to serve a notice of related case if somebody else has already did it. If somebody else beat you to it, you don't have to do it, okay? You could, of course, file your response as to whether or not it should be related or not, okay? That should be self-evident. All right, let's look at the form. This is the notice of related form, all right? Learn it, love it, become it, okay? And here's a clue on the form. Status of the case. This is the actual judicial council approved form. Pending, dismissed, disposed of. There's your clue that you don't. Besides the wording of the statute, the notice, the form itself tells you that it could be related, even though the case doesn't exist anymore. Okay, and this is a little fun fact. I don't know if any of you know this. You might. Every form there is that's been created by the Judicial Council says form approved. It'll say for optional use or mandatory use. A lot of people don't know that. It's in the lower left-hand corner. It will say either one. Every Judicial Council form will say either it's optional, mandatory. There are mandatory forms that you must use. For example, if you want to withdraw a notice of motion to withdraw as counsel, they're mandatory forms. Don't create your own pleading. You must use all the forms. It's mandatory. This is optional, okay? I would urge you to use the form anyway, okay? But technically you don't have to. You can just, as long as it has all that information in there, okay? Case management statement, all right? For those of you who practice in the IC courts, this is a mandatory statement, okay? Mandatory, all right? And you have to fill this out for your case management conferences. Now I should do a MCLE just on case management conference forms, because it just drives me crazy what people do, okay? Like, for example, under describe the case, 4B, briefly state the facts. They just say, wrongful termination. Well, how does that help me, all right? FIA, okay? Tell me something about the case. Use an attachment. I don't want an opening statement, but I want something that distinguishes you from the other 400 wrongful termination cases I have, okay? But I digress. Let me get back to this form. Look what we have on page 4. Oh my God, paragraph 13. How many of you actually realize there's a paragraph 13? Because nobody fills it out. I bet you the fill out rate is less than 5%. Okay? A lot of you do sometimes. It's a mandatory form. Okay. Now you should have filed your notice of related case before this anyway, but this is kind of a gentle reminder. You're under an obligation to tell me if there's a possible related case. Okay. And it says you can use attachments. So I always look at 13. And all the time, like I have a good instinct. They talk about there was a previous case and now they breached the case and they didn't follow up and then there's a new case. I'm thinking, well, wait a minute. I'm reading the complaint. It says, they're talking about another case. Why didn't you file a notice of related case? Of course, their response. Well, that case doesn't exist anymore, Your Honor. Well, we all know that's not correct. So in the mandatory form, it does have a paragraph 13 that talks about notice related case. You can leave it blank if there is none. But when you leave it blank, you are telling me that you thought about it and you considered it and you don't have any reasonable belief that there's a possible notice of related case. That's what you represent to me when you don't fill it out. Okay? Think about it. All right. So let's just say a judge grants a notice of related case. I grant most of them. I bet you I probably grant 95% of them. Okay? I really do. You have no right to a de novo review by Department 1. Remember what I said. You can only file the motion in Department 1 if it's a denial. You don't get to appeal a grant, believe it or not. Right? And I double checked the statutes. You do not have a direct appeal under those appeal sections. All right. So what's your relief? I'm going to assume you could have writ relief. That's stretching it. Okay. But I guess if somebody grants a notice of, you filed an objection, you made a very persuasive case why it should not be related. They're not substantially similar issues, blah, 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 blah. And the judge just grants it anyway. We know you can't file the motion in 1. We know you don't have a direct appeal. I guess your only remedy is to file a writ. And I guess it would be an abuse of discretion standard. Good luck on that one. Okay. But I guess it's there. All right. Now, this is the most apt one. Notice of related case. All right. Let's just make it easy. 2 cases. Case 1, case 2, in that order. Case 2 gets filed. They give the notice of related case under case 1. The judge in case 1 grants it. Okay. And it says, 2, you're now coming to me. Well, wait a minute. I don't really like that judge. I don't think that judge is fair and impartial. I know that's hard to believe, but maybe some of you guys think that way. Okay. So I want to exercise it, and they're not continuation cases. Okay. Which they wouldn't be very unusual because it's a pending case. If you still have a paper in the case that's being moved, case number 2, if you still have a paper, it starts a new 15-day clock. All right. When you get the notice of related case that was granted, you get that minute order. If it's served electronically, you have 17 days to paper the new judge, the case that it's being sent to. All right. And I always tell people it's like The Godfather. Nothing personal, it's just business. All right. It's nothing personal, it's just business. Do what you got to do. All right. So you can file your 170.6 if you still have it available. Okay. If you've already burnt it, you're out of luck. All right. You're stuck with the new judge, the judge that's being sent to in case 1. But if you have a paper, you can still paper that judge. This happens all the time. And so what happens is this. Okay. Judge 1 grants the notice of related case. Okay. Takes case 2. Everything gets vacated in case 2. It comes to case 1. Starts this clock, 15 or 17 or 20, right? 15 plus 2, 15 plus 5, depending on how it's served upon you. All right. And then you timely exercise your 170.6. It's a righteous paper. That judge grants it. So now what do we do? Here are the options. I'm now a disqualified judge. I can send both cases to Department 1 and let them make the call. All right. I'm righteous on the first case. All right. That's my case. The papers have already been extinguished or they're not available. I relate 2. 2 comes to me. Somebody had a paper in case 2 and they filed it timely and it's righteous and I grant it. So what do I do? Because I related the cases and possibly they could be consolidated. I have an option. 1, I can send both cases over to the supervising judge and let the supervising judge decide. I'm going to tell you right now what they're going to do. They're going to unrelate the cases and send them all back to their corners. Okay. That's typically what 1 does. But maybe 1 might look at it and say, you know what? These really need to be related. So I'm going to send them now back to 2. And now this is where 1 can go to 2. Or I'm going to send it to a completely different judge. And then we play the same dance over with the people in one, if they still have a paper. You see what I mean? So you could send both cases, or believe it or not, I'm the one that decided the notice of related case, right? And I said, I grant it, right, within my discretion. It gets sent over, it gets papered. The paper's righteous. I grant it. I can, if I want now, reconsider my notice of related case ruling and just unrelate them and send everybody back to where they were. And I typically will do that if I don't feel strongly. If I feel strongly that one judge should really hear the case, and we know that I cannot hear case number 2, right? I can't hear it. I'm disqualified. I can let Department 1 make the ruling, okay? Right, and so, but typically if it's, it was a close question or it's not that big of a deal, I'll just reconsider my earlier ruling relating the cases and just unrelate them. And everybody's back to where they were, okay? And that is not unusual for that to happen. No harm, no foul, okay? All right, basically the conclusion is that you really need to start thinking about related cases. And even if they're across, between different courts, superior courts, between different family law, probate, things of that nature, you need to start thinking about them when you file a new case, okay? So you only need to file it when you file a new case, okay? Then you need to think about it. So in the case management statement, give it some serious thought, okay? And then again, that's just my little comment. It's not like to be or not to be, I'm contemplating suicide. It's not the end of the world, but you should take it seriously, okay? Because there are reasons, good reasons why we should be doing this. And as Shakespeare said, lawless are they that make their wills their laws. You don't get to make the decision. The judges get to make the decision. You're just under an obligation to tell them there's a decision to be made. And you should err on the side of caution. It never can be wrong to file the notice of related case. You could file the notice of related case and say, I really don't think there should be related for these reasons, okay? All right, so that's pretty much it. If there are any questions, I'm glad to hear them now, or complaints, or I can't hear you, Ms. Kogen.
Sorry about that. Thank you so much, Judge Hammock. We do have a couple of questions. The first question, how about civil harassment restraining orders with the same parties as in the civil cases? Do we
I
need?
knew someone was going to ask that question. Judges call me all the time from the restraining order courts. Again, it can never really be wrong to file the notice of related case. But my understanding is that there's already a protocol in place. You have an existing family law case, right? And then you're trying to get an harassment, a restraining order, and you file it down in the Rock in 2B, okay, at Mosk, and you get the TRO issued or something, right? And then set preliminary hearing. You need to file the notice of related case and let that judge in the family law case make the call. And maybe the judge should take the case to hear the restraining order. I think getting the emergency TRO, you might be able to do it without the related case because it's an emergency. But I think you need to file the notice of related case even. Now, don't forget, there's different type of restraining orders, but if it really is the petitioner and the respondent or people related to them, maybe it should be handled by the family law judge. Makes sense to me. Okay. All right. But
All right.
Maybe there's other civil harassment statutes, right? The 527 ones, right? That are there's not necessarily a pending dissolution, correct? So maybe there's nothing to be filed there. If there is a pending family law case in which it's possibly related under those 4 factors, including the catch-all, I would file the notice of related case and let that. But again, I think there are protocols automatic.
Okay.
I think the protocol,
if
let me just finish. The protocol, my understanding, I'm not in family law, never have been, is that the judge can issue the TRO and then set the hearing for the preliminary to the family law judge that has the case. That's my thinking of the protocol.
So just to follow up with that, if there's related matters, say in a probate case and a divorce case, do you need to file the notice in both the divorce court and the probate court as
You know
well as
what?
Department 1?
I think the form says civil cases, doesn't it? go back to the rule, okay? Go back to the rule. I gave you the whole, I think you only file the notice of related cases in civil cases, but I think you, because let's just say it's family law and probate. I'm not quite sure what happens. That's a good question. I really don't know. I do know the answer when it's civil and family law and civil
Okay.
and probate, or civil and both. Obviously, the civil judge, the supervising judge makes the call.
Got it.
But I don't know about the other two, but good question.
Okay. I think that's all of our questions. So thank you very much, Judge Hammock. This was very informative for everybody. And,
Well, I hope everyone learned something, because I really feel strongly about it. That's why I wrote the article, because it is important. And a lot of people show up and they're just, like I say, they've never looked at the rule. I always say, just look at the statute, look at the rule. They're usually pretty well defined. And I hopefully you could find this as a practical thing to do. Okay.
absolutely. Well,
Okay.
we're all going to be looking at those case management statements more carefully going forward.
I appreciate that. All
Thank
right, you
you,
guys
Judge.
all be safe and good out there. I'm going to sign off. Thank you.
Very good. Thank you, everybody, for attending.